Medical malpractice remains a complex area of the law. Jack Gordon from Maney Trial Lawyers is back to discuss how the law has changed in the past few years, possibly in favor of patients. Good morning. Good to see you.
Good morning, Carly. Always a pleasure to be here with the finest hostess in Tampa Bay.
All right. I thank you. I appreciate that. Let's talk about medical malpractice. This can be a very complicated, as we alluded to, form of law. Why is that?
Yeah, I think the important thing for consumers and patients to understand is that the medical malpractice laws in Florida, and this is true in other states, are not designed to protect the patient. In all fairness, the laws are designed and lobbied for by healthcare provider entities and big medical organizations, essentially to insulate physicians from liability. But there have been some changes during the course of the past 4 or 5 years that have been pro-patient, one of which is, of course, the elimination of damage caps in medical malpractice cases, both from a wrongful death perspective and personal injury.
Are those all different within the states?
Those are all different because the laws, again, of each state govern how a particular claim is asserted and what the limitations are. Here in Florida, again, up until 2014, if a patient was killed as a result of medical malpractice and the surviving family was determined to have suffered damages, pain, suffering, mental anguish, and the like, let's say a jury, again, a jury of peers, after considering all of the evidence, the jury awards $2 million. The maximum that physician would ever have to pay is $500,000 because of the cap. The Florida Supreme Court struck that cap down in 2014 in medical malpractice wrongful death cases. And then in the following year, calendar year 2015, there was a case called Callatan in which the Florida Supreme Court did the same thing for medical malpractice personal injury. So again, if you lose your leg as the result of hospital error, prior to 2015, and the jury were to award you $2 million by virtue of the loss of capacity of the enjoyment of life, you've lost a leg or you're now paralyzed, you're awarded millions of dollars. The maximum a doctor would ever have to pay is $500,000. Not so after the calendar year 2015. So again, there is movement in favor of the patient, but it still remains a very complex form of law, and it's still a tremendous heightened evidentiary burden for patients to prevail.
And I would imagine it's complex because there are, it's medical issues, especially when you're trying to explain this to jurors. Talk about the importance of scientific knowledge and what your team can bring to that, and again, why that is so important.
It's interesting. It's one of the more challenging issues we face. We're trained as lawyers. We went to law school. We achieved board certification. We have a tremendous amount of experience trying cases. But at the end of the day, we are still teaching substantive medicine to jurors and persuading them that showing them, illustrating how a particular physician or healthcare provider committed error. So when you come to my office, you'll see that there are not merely bookcases of legal books and statutes, but there are a whole heck of a lot of medical school textbooks and medical journals. We subscribe not merely to lawyer journals, but we receive every month peer-reviewed journals for medical professionals. And of course, in addition to the continuing legal education seminars we attend, we are now attending, and have been for a number of years, attending professional seminars that are conducted specifically for healthcare professionals. So we're sitting next to the very same doctors that we're suing.
So, wow. Well, as we get ready to close here, for people watching, maybe they think they might have a case. What would you say to them? What would be your advice if you're just starting this journey?
Well, again, there is a tremendous amount of information available at people's fingertips right now by virtue of the internet.
Which could be a good thing or bad thing.
Maybe a good thing or a bad thing. Don't get too hung up on WebMD. Oh my God, I think I have stomach cancer. No, you probably just have gastritis. But it is important to listen to your own body, and it's certainly important to do the research. And if you do suspect that there has been error committed, then check it out. The statute of limitations is restricted in medical malpractice cases, so the sooner you contact someone, the better. And at my law firm, the majority of what we do is pour through medical records and medical charts and lab reports. And if there is any evidence that some healthcare provider has committed error, we'll probably be able to find it within those records.
All right, we'll put your information up so people can make sure to get a hold of you, whether it's on the website or calling in. As always, we appreciate your time.
Thank you so much for having me, Carly. Thank you.